So moving on with our contract thing here, back to, now we're on paragraph 10, talking about prorations. So these are for those items that have been paid in part or in full, rather, that maybe should only have been paid in part because they were annual costs. Could be any number of things. So some of those items are just, here that those could be, what they could be and what they could be dealt with. So those dollar amounts would be listed on 90 and 91 for things like association fees. Then on pages 94, or lines 94, 95, 96, here's where you're going to deal with the real estate taxes. That's usually the big proration number that we're talking about. So the normal thing that goes on with taxes, right, is that they go up every year, 2, 3, 5, 8%, whatever it is. And the idea here is that you, as the buyer, can negotiate with the seller for what kind of percentage of the most recent bill you're actually going to get paid. So if the last year's bill was $10,000 and you don't have this year's bill, maybe it's going to be $10,500. So why take 100% of the taxes when you're that far behind? You ask for 105% or 110%. In commercial property, the largest tax increase I've seen year over year was in excess of 30%. So if you're negotiating the purchase of a commercial office building, you're not using a form like this, but you might have what they call a reproration agreement, where when the new tax bill comes in, the parties actually divvy up the actual bill and the right amount is paid because it's too big to handle. So on foreclosures and distress sales, short sales, oftentimes it'll say taxes prorated at 100%, because in those properties they're expecting that the tax bill is going to go down when the property gets reassessed because of the below market sale. But the norm is that it goes up. So that's what this line is for on 95. And the most common two numbers you see there is 105 or 110%. Handle it how you like in negotiations with your clients, but that's what it's there for. Paragraph 11, attorney review. This has been a changing area of these contracts over the years, and I think it's a very poorly understood area by real estate brokers. See if I can explain it without screwing it up. So under the attorney review privilege, basically the attorneys for the parties, and remember this is another reason why you want to convince your buyers that they need to have an attorney, because this then means something to them. Otherwise, as the buyer's agent, you're having to play that role. It's not really a position you want to be sitting in. But as an attorney, you have the review within 5 business days, have the right to propose modifications to the contract in all areas except for the price. I think that's really pretty much it. It's the only thing they can't touch. Commercial contracts, you'll oftentimes see price and broker commissions, interestingly enough, are oftentimes excluded from attorney review. Anyway, so here you have really a couple of options with these. Either C or D is a little bit different. So once it's in that attorney review period, which by the way the attorneys can extend, and so this is part of what happened with that Lytle case. Maybe you have the attorneys involved, and the attorneys can at any time just mutually agree as their client's agents to extend contract terms. So under the attorney review period, the attorney review period oftentimes gets extended. It's for 5 business days, but if they're still negotiating some language issue, they don't want to kill the deal either. They're trying to work out nuanced language, and in the meantime, they just keep extending the attorney review provision while everything else around it is going on. Financing is being applied for, and inspections are being done, and all the rest of that. So under C, proposed modifications except the purchase price. If within 10 business days after the date of acceptance, a written agreement is not reached by the parties with respect to resolution of the proposed modifications, then either party may terminate the contract by serving notice, whereupon this contract shall be null and void. So there, if the attorney provisions that are suggested are done under paragraph C, if it doesn't get worked out, the deal can be declared dead. That's a dangerous position for either party to be in. You're proceeding, the buyer's paying for inspections, paid for an appraisal, paid for whatever, and the deal can still die because this is open. So instead, if a suggested change is made and it's made under paragraph D, they're not agreed upon, the contract continues on without those modifications. See the big difference there? So it's very important that understanding that attorney review, you don't really know what kind of attorney review situation you've got until whichever attorney writes a letter suggesting modifications and clarifies whether it's meant to be covered under paragraph C or paragraph D. attorneys typically choose paragraph D because they don't want to be responsible for killing their client's ability to buy a house or sell a house because the other party finally says, screw it, forget it, we just don't agree and the deal's dead and we're going to go to somebody else. If you have residential real estate attorneys who are used to this contract, they know exactly how to play the game. Attorneys specialize like every other field. The attorney who does medical malpractice and now is just doing his friend a favor by helping him do, close his real estate transaction doesn't necessarily understand this because he hasn't done a real estate closing in 20 years. So hopefully he picks up on that. You have to be careful what you say to your clients, but you can say anything you want to your client's attorney. So if your client's attorney is a sophisticated residential real estate attorney who does this a lot, they know the contract better than you ever will, that's a great place to be. But if they're not, feel free to point out the concerns you have about the contract, about certain provisions or whatever. Make sure they understand how it works. They will appreciate you for that. Most attorneys who do real estate are easily approachable, they're friendly, they're happy to be doing this, they're not making a killing, they're not litigation lawyers. If you don't know many attorneys, you'll find that most attorneys are good people. It's just big, high-dollar downtown trial litigators that are the ones that are the biggest challenge, or any attorney who's questioning you in the middle of litigation or an arbitration or something. But otherwise, make sure that your attorney knows how this is going to work. Paragraph 12, inspections, give some dates, times in here. This is pretty much for anything except for well and septic inspection, which is an optional provision later in the contract. So again, points out in here basically lines 115, 116, you probably saw this when you read it, that here are all the options to the buyer. Home inspection, radon inspection, whatever. They're all there as options. Then it gives you time frames. You got to have the inspections done really quickly and the reports submitted back. So you need to have an inspector recommendation to your buyer client. Once you go to contract, that inspection's got to be done within a couple of days. Some home inspectors will hand you a printed copy of the inspection report at the inspection. Some will email it to you by the end of that day, or to the client, or whatever. Make sure that you get a copy of however it is, make sure you get a copy of it. Many times, if you as an agent attend an inspection with your buyer, the inspector will print out 2 copies, one for the buyer, one for you, and then you can scan that in if you don't get a PDF of it or whatever, and forward it to your buyer's attorney. So if there are any issues, they've seen it, they're aware of it, then they know what it is. And of course, if you're going to make claim under the contract from the seller to fix certain things, if you're able to do that, they would need to get a copy of that inspection as well. Again, have 2 or 3 of all these professionals that you can recommend to your clients. Keep their cards, their contact information handy with you at all times. Homeowners insurance explains in here that, that's a requirement. Basically, it's a contingency now that it has to be obtainable. With the CLU database, the, what is it, Comprehensive Liability Underwriters, whatever it is, CLU database, claims on houses on individual properties are all in this database, and your ability to get insurance also sometimes is predicated on your credit score. So you suspect you're going to be able to get insurance at a reasonable rate. You may or may not be able to, so the deal's contingent upon that. So again, apply for it, get it ahead of time. Flood insurance, if it's required, that's paragraph 14. If you have a common interest association of sorts, all that information is in here. If you're representing a seller, make sure you have a copy of the bylaws, the rules, regs, the restrictions, the CC&Rs available. Have a copy of it downloaded and available from the association if it doesn't cost you money, or have a website link available so the buyers can see that and have access to that and know what they're getting into. Find out if you're, what the deal is that. As soon as you get the listing, if your sellers don't have a copy, what's it going to cost to get a copy? Make that your seller's responsibility while you're the listing agent. Make it the buyer's, make it available to the buyer, or try and make it the buyer's cost. But usually it's going to be the seller's expense, unless something else is agreed to. and all the nuanced details about all of that that goes with it. I think, yeah, most of the next series of paragraphs are pretty straightforward. These are things that you're probably not going to be explaining. Anything where you don't have blanks to fill in, you shouldn't have any real concerns. Again, you can't really explain anything, any legal significance, but understanding sort of the mechanics of how it works makes it easier for you to be able to walk them through the processes here. Paragraph 19 on page 5, plat of survey. In some foreclosure situations, REO property is already taken back by lenders, the lender won't provide the survey. It's right in the MLS, it's part of the criteria, so know that if you're signing a contract form, this may say sellers to provide the survey, but lenders will oftentimes require there to be an addendum signed, and that addendum specifically says seller's not providing a survey, regardless of what the contract says. So make sure if you have other riders or addenda that the seller is requiring, maybe it's a relocation package, as I mentioned, the lender, any other situation like that, make sure you know about any conflicts between the two and what they're getting. It isn't that your buyer can't buy the house, it's that they're gonna have to spend $400 or $350 for a survey. No lender's gonna provide financing without a current survey. So it's a buyer financing issue. We just customarily ask the sellers to provide them as part of the contract here because it's cash out of pocket and it's the seller's property and they have the right to invite a surveyor on the property.
Is there an expiration date on a survey?
6 months usually. It's really up to the lender. Most lenders will accept a survey that's up to 6 months old as part of financing. Maria could confirm if I'm wrong on that. After that, it just, they get uncomfortable because if things change, then how are they going to know? Of course, surveyors don't know about adverse possession or prescriptive easements or those kinds of things that aren't written. Surveyors and title search combinations, if you're doing an ALTA survey, for example, for a more complex property than residential, they might list things like liens and other encumbrances actually on the title or on the survey itself. Much more complex document depending upon what you're looking for. But usually for residential, it's 6 months. Now, if you've had the property refinanced or surveyed recently because you've only owned it for a couple of years, call the same surveyor. They usually knock off $50. They call it an update. They come out and do the same things, but they just go off their own records. It's a little bit easier and cheaper for them.
My lender doesn't require a survey.
Oh, you really don't require any more at all?
No.
Interesting. What are they working off of? Do you know? Or are they just?
Title.
Then they're happy with that. That's very interesting. I was unaware of that. So yeah, but it's just for Illinois, as far as you know.
Like Florida requires one, we have to have one. But Illinois, California, New York, Texas needs one. But California, Illinois, New York, they don't need one. Those are most of the states.
I wonder why that is. I wonder what the difference under the law or procedures are. I wonder if it's something in the title insurance or something. I don't know. That's interesting. All right, so maybe you don't even need a survey. I don't know, but these contracts require the seller to provide it. Interesting.
If they have it, they'll take it, but we don't require it for closing.
Usually they're not ordered till about not 4 days, but about 5 or 6 days before the closing, and make sure everything is done and go from there. How about that? I should take this class. I might learn something. Paragraph 20, 21. Well, 21. Let's talk about house broom clean condition. Sometimes sellers are trying to figure out what condition my property has. Do I have to wax the floors? No. What does broom clean mean? No dust, no, whatever. Just get the garbage out. Don't have scraps of paper or garbage laying around, and that's it. If you're talking about spit polish and everything, do that for the listing after that. I mean, theoretically, the buyer buys the house in the condition it's in it the second the contract is signed, but that doesn't mean you have to, put another coat of wax on the floor 6 weeks later when you close. That's just not how this works. So leave it in broom clean condition so that the buyer can figure out what they're doing with it after that. There is a legal definition to broom clean. It's case law, common law, but it means something in the courts. Tax escrow, again, I think that's pretty straightforward. Seller representations, it's just sort of warranties or guarantees. These are the things that survive the closing. So as we talked, I think, earlier in the other class, it wouldn't be in the online course, the idea that the contract merges with the deed. So promises in the contract are considered fulfilled at closing typically. And if something changes from contract to closing, it's oftentimes considered like a mutual accord and satisfaction, in other words, a renegotiation. So if the seller agreed to replace the windows and it comes time to the closing and the buyer says, you never replaced the windows, and the seller says, I'll do it after you've been in the house for a month, and the buyer goes ahead and signs, they're probably screwed and not gonna ever get any windows, because they've just basically effectively said, sure, we'll take it in the condition that it's in now, even though we originally agreed to new windows. So that kind of thing, I mean, maybe it's a stretch with my oral statements there, but without that, you would be basically saying, fine, we'll take it in the condition of closing. So it's important to spell out those items that survive the closing that don't merge with the deed, to make sure that it's clear to the seller, these things that come up will come back to bite you later. If you haven't told us about them, or there are problems with these things, it's a little bit like the warranty of covenant of warranty forever under the general warranty deed, that these things survive the closing and could still be challenges. So again, understand that, and also down here, if you're in a special assessment area, or if there's any kind of an assessment, that gets disclosed on lines 257 or 259. So you have to know if the house is in an SSA to list it. The buyer's agent should look for that. You all remember what an SSA, or familiar with what an SSA is? Where the funding for the development came from municipal bonds, and it's being paid back by the homeowners, not by the developers. So the purchase price of the homes tend to be less, but you're paying more basically in what appear to be part of the tax bill. So in that case, that's got to be disclosed here. So know whether you're in an SSA or not. It makes a big difference. Like Lakewood's developments in Plano and Montgomery are SSAs. There's a number of places around in Oswego and Southern Aurora that are SSAs. And different developments across the street from one another. One will be an SSA and one will not. So know which is which. All right, let's see. What else here do we want to notice? I think those things are probably reasonable enough. Yeah, just the last few paragraphs in here. I mean, like looking at 28, 29, 30, or excuse me, 27, 28, 29. Notice issues. The addresses are important. Who the representatives, the attorneys are. Performance. Illinois law, good faith. That's all pretty standard, straightforward stuff. Time is of the essence. That's straight out of the textbook. So again, that puts teeth on these deadlines. If anybody doesn't do what they're supposed to do within a given date, they're in breach of the contract, subject to penalty or termination or whatever the other party might want to apply. All right, and so that's the contract. That's it up through paragraph 30. That's what you're signing. Questions about any of that? We're not done, but questions about any of that at all that we've gone through so far? Other than the signature page at the end, then everything else from this point on is optional. Doesn't apply unless the parties have all initialed it. Still worth going over. So if you have dual agency, it should get confirmed here on line 31. So the parties both agree that they're good with dual agency. That way you don't need a separate form, it's just right here. Paragraph 32 goes back to the contract chapter and the contingencies. This is a real contingency, contingent upon the sale of my house kind of thing. So again, know how to use this better in practice. I'm not going to take all the time it takes to explain this. This by itself should probably be an hour lesson. But the basic idea here is when a buyer purchases a home contingent upon the sale of some other property of theirs, usually their current residence, and then they want to make sure that if their current house doesn't sell, then they can get out from underneath the contract to purchase this house. If a seller agrees to that, the seller wants to have the right and ability to take other offers, to continue to show the property, take other offers, and when they get a non-contingent offer, an offer that's not contingent upon the sale of the property, go back to their original buyer and say, you've got X number of days to waive that contingency or waive bye-bye to the house, and we'll go with these other people. So that's what this whole paragraph is all about. Is it on the sale of buyer's real estate? Is it contingent on the closing of their real estate, because that matters. If it's under contract, you can still make a deal contingent on that other property closing. Sometimes theoretically, you don't know if this contingency's over until 20 minutes before you're closing. The other people are at a closing table across the hallway, and when that deal's done, they walk right in and you close your deal. You know, you can have a feeling about it. It seems like it's going to go through, but you want to have all these contingencies. So if the thing is contingent, if it's going to be contingent, is the home listed? You know, if so, what are the details? What's all the information? The listing agent, the seller, they're going to want to know about this property. They're going to know, you know, something about it, what kind of the situation. So that's what all these details are. The kick-out information, let me find this here really quick, excuse me, is going to give the buyer either 24 or 48 or 72 hours to get out from underneath, you know, to waive this rather, and then, you know, and take the deal or not. Yeah, so that kick-out clause is on line 372. It's usually 24, 48, or 72 hours. It can be whatever you want it to be, but those are the three that you see. In fact, the MLS has standard data fields here for either 24 or 48 or 72 hour notice. So what that does, let's assume we use the median and say it's 48 hours. That's when the buyer would be given notice. So the seller gets a second offer, which is a backup offer, like the offer in the Lytle case should have been a backup offer and a backup contract. And then the first buyer would be notified that, okay, you've now got your 48, we've got this other offer, 48 hours starts now, and you've got 2 days to then waive this contingency. And that buyer has to decide, okay, can we buy it? Maybe it's not even an option. They just have to say, we can't do it. Or maybe they have enough money, they just didn't want to take the risk of having 2 mortgages. If the contingent buyer waives the contingencies and says, fine, we'll close, then the backup offer never becomes anything but a backup contract, never becomes anything but a backup contract, and it goes away when this original deal closes. If they can't, then the contingent buyers go away, the backup contract becomes the primary contract, and that one then is in the driver's seat with all of its terms and conditions. Everybody follow that okay? So again, you know, understand well how to use this. As a, you know, as a listing agent, you can't necessarily allow your seller to get into the situation depending upon the market, depending upon their circumstances. Sellers may or may not want to do this. There's not a one-size-fits-all right or wrong answer to whether these are a good idea or not. It's based upon market conditions, your seller's situation, and the property may be out of state, so you may not even know what the market conditions are. Pick up the phone and call the listing agent on the other house, talk to them about it. In some cases, the buyer's agent is the listing agent because it's just across town or 10 miles away, and they're handling both sides of it. Then talk to them about it. Get all the descriptions, look it up in the MLS, see how many days it's been on the market, talk to your client about it, all the while you're still negotiating the deal. All right, any questions about that whole range of, again, it's a pretty long, multi-page sort of thing. Paragraph 33 over on page 10 is the contingency for the backup offerer. So when you make the backup offer, it's got to be, number 33's got to be in place, because you can't, you know, the seller can't sell the thing twice, right? So the buyer's agent should already be explaining to their people, we're going to make this as a backup offer. You do that when inventories are thin, somebody really likes a place, you hear from, you know, rumor that maybe the other deal is going to fall apart. So, you know, in that particular case, the second deal's got to be contingent upon the cancellation of the first. So that would be what that one is for. Paragraph 34, home warranty. You know, is the seller offering it? Does the buyer want one? You know, what the situation is, take a look at that, and that's where that would be specified. Any kind of credits, so sometimes the seller will agree to pay closing costs for the buyer. It's typical, not typical, but common in, say, an FHA or VA loan, where it's a little to no cash down type thing, and the seller's got to help the buyer by coming up with cash. Usually the buyer pays the asking price, and the seller, instead of taking a discount on the price, coughs up some cash for credit at closing. Debit to the seller, credit to the buyer. 36 is where we talked about earlier regarding the finance, okay, so now we know it's a not contingent on financing, but is it a transaction with a mortgage, or is it a transaction with no mortgage? That's what this is to tell you. We had cases in the middle of the recession where lenders had issued, finance commitments and then would just not follow through with them. Not because the buyer's circumstances had changed, but because the lender's underwriting, criteria had changed so dramatically during the period that they couldn't honor a creditworthy borrower anymore. That kind of thing was what was crazy, what was going on in 2008, 2009. Perfectly good, high credit borrowers get a commitment letter and then couldn't close. So, you might think you're a cash buyer, but then your financing doesn't come through. That's giving the seller notice what kind of cash buyer is the other party. Paragraph 37, if it's a VA or FHA loan, that should be spelled out. There are additional review criteria, property condition review as part of the appraisal. An appraiser is not an inspector, but FHA and VA loans require their appraiser to look at a valuation condition situation and make sure that certain things have been done. It used to be much more extensive than it is today. I say this to you not so you'll know the history, but so that you know that it could go back to being more that way in the future. All the government agencies have to do is get a little squirrely about it, and it could be more complicated. It used to be 6 pages of checklist. Everything from if there was any wood on the house anywhere that was in contact with the ground, any exterior wood at all that was unpainted, a front door without a storm door, outlets that had to be ground fault, interrupter, GFI outlets that weren't, then the lender wouldn't fund the loan. I had to have a 2-year roof certification if the appraiser called for it, any of those things, and you couldn't get them. And the challenge there for a seller is if the appraiser says the property doesn't meet the FHA or the VA's condition requirements, you've got a deal contingent on financing, and it's not the borrower's problem, it's the seller's problem. Because the seller's got a house that won't meet the condition and the buyer can't fix it because they don't have the right to go in and do it and they don't have the cash. So now the seller's stuck on an FHA or VA loan in those rare circumstances today going, oh, do we want to spend the $200, $300, $500, $800 to fix it to close the deal? Some sellers will say conventional financing only. If you've got a rough house, FHA and VA may not even be an option. And you can specify that in the MLS, by the way. Well or septic or sanitary systems, those inspections are usually paid for by the seller, and that would be done here. Termite infestation issue, again, is dealt with here. If you have this is in addition to whatever other inspections you had, so if you see a house and it looks like there's termite infestation, you might want to use this paragraph. This paragraph 40 is a license basically granted to the sellers. Okay, we're going to close and you're going to be able to stay in the house for a while. So attorneys used to have to grab a form and draft this when it would come up at closing, but now it's right here in the contract. Paragraph 41 is the as-is condition. Paragraph 42, is there somebody else that has to sign off on this deal? A parent who's providing money? A spouse who's out of town, who's already been relocated? Whatever it might be, this is where you specify. Somebody who's not on title, but if they don't approve, we can't do the deal. That needs to be spelled out here. I had a deal once where it was the guy's money was held in trust, and it was one of his siblings that had to approve the house purchase. So we could go to contract, but we couldn't. It was a contingency. It had, the brother or sister, I think it was, had to come and look at the property and make sure it was okay. 43 is really kind of a note to the brokers, but if you have buyers who are putting down a lot of earnest money, and they want it to go into an interest-bearing account, this is where you would allow that to happen. All escrow deposits are non-interest bearing in Illinois on all real estate transactions unless the parties agree otherwise. So this becomes basically a letter or provision of direction from the buyer and seller to tell whichever broker is gonna hold the earnest money, it's gotta go in an interest-bearing account. This also gives notice that up to $100 can be charged by that escrowee, that escrow agent, to open that account, which for any reasonable person should disabuse them of the idea that they want an interest-bearing account. If you run the numbers, $100,000 for 60 days, it's, 15 bucks. Who puts up 100 grand in earnest money? So, I mean, it's just not worth it. And brokers are saying, hey, we'll do that, but, we don't owe you that, and we're not doing it for free. So you're gonna pay for an hour, a couple hours of our clerical time to do that. Most firms charge anywhere between $70 and $90 to do that. And then you got some miscellaneous stuff that's there in paragraph 44. There's also a couple of riders, like a short sale rider. I think I have that posted online, but I'm not gonna go over it with you here. And there are a few other rider or addenda that you can find that are pre-printed and pre-made for this form that I think are already available for you online in the course shell if you're interested in just seeing what those are. Again, you have a copy of those handy or have them on your hard drive or whatever device you're working with, so you can bring those up and add them if they apply. Questions about any of that stuff that we've gone over? So the last page here, the top third of it is part of the contract and the bottom 2/3 effectively are not. So the top part of it is where the parties sign. Please note that a contract can only have one date. That's why there's not a date on the front page. You might be used to seeing contracts that will start off on the front page and say, as of this first day of May 2015, whatever. That's a terrible idea. Contracts can't have a date one place and then have signatures with dates in another place. You only have one contract date because everything starts from that one date. It's when the clock starts ticking. So you've got an offer date in the upper left-hand corner when you first make this offer. But this date of acceptance should not go on here until there is nothing left to negotiate. When the last party dots the last I, crosses the last T, there's no more initials to be done, that's when the date of acceptance goes on there. And for whatever it's worth, in my opinion, if it's 11 o'clock on Sunday night, date it the next day, for God's sake. Give people the time they need to do stuff. Don't short the parties a day. Because that's the official date of the contract, that date of acceptance. So you get buyer signatures, seller signatures, print their names, that information, their contact information. So everything from that point up, that's all part of the contract. Below that, not so much. Put your contact information, the attorneys if you have it, lenders if you have it, HOA, whatever else you've got, fill that information in. If you don't have it, it has nothing to do with the contract. But this page becomes sort of a record that everybody involved in the transaction can refer to and say, aha, I do have the phone number for that other attorney. I do have the information for the broker, for their lender, for whatever. It's all in one spot. So that's a point of convenience for everybody. The more of that information you could fill out before the contract is officially formulated, the better off, because then that final form of the contract incorporates all the contact information that would be needed. Then many people brokers like to use this timely thing. I presented it at this time, it was rejected and sent back. It's maybe helpful, but I don't know how critical that is. And when you go back and forth 3 or 4 times, there's really no place to put all that information. Again, it's there for you to be able to verify we presented the thing in a timely manner. Clients have no obligation to respond in a timely manner, but you have an obligation to present in a timely manner and to keep them informed in a timely manner. Questions about anything at all in this contract form or contract law or any of the stuff that we've kind of talked about in that case? Another thing you need to read that's on the course shell that's not worth us going over in time here, it's a page long, and I suggest you print a copy of it and keep it handy. It's about a 10, 15, maybe 15-year-old document from the either the Realtor Association of the Fox Valley, I think it was prepared in conjunction with the Kane County Bar Association. It says the role of an attorney in a real estate transaction. It's just really simple, but it kind of lays out for you, this is what an attorney does. These are the services that an attorney provides. And you should just keep that handy until you get familiar with it. Once you've been through 3 closings, there isn't anything else. You know what they do. But it can be helpful for you, and if you have copies of it, you can hand it out to your buyers. I can't encourage you enough. Buyers are always, not always, buyers are usually strapped for cash. I don't even know if I were buying a house tomorrow, I don't know whether I would, and I have friends who are attorneys, I don't know if I would hire one. But I would not be happy if I had a buyer client who wouldn't spend the $400 to hire an attorney. Because I don't want to be in a position to be their attorney, you know, because you can't be, right? So recommend they have somebody. Most of the documents at a real estate closing are for the buyer. Most complicated documents there, the biggest volume, are the lender's documents. And even if the lender is kind enough to show up, they're not there to represent your buyer or their borrower. They're there to represent themselves. And they may explain what those documents mean, but they're not there to give the buyer a full sort of legally vetted explanation. Only an attorney can do that on their behalf, and so that's part of what they get, is the attorney looks at the loan docs, looks at the closing documents, makes sure everything's right, goes through, does attorney review of the contract, and then of course shows up at the closing and handles any problems, or refers them to another attorney if there's a grounds or basis for litigation or arbitration or something. But you should, urge you to recommend to your buyers that they have an attorney. Even though they can close a transaction without one, in Illinois it makes it awkward for you because of the Quinlan Tyson case. You just don't want to be in that situation. I will tell you that I've been at closings a number of times, explaining closing documents, going through the title statement, and sometimes I'll just look up and look at the other attorney, and they'll usually nod or say, like this, keep going, you're doing fine. My experience with residential real estate attorneys, those who do this a lot, they see that a lot. And I've even had cases where a seller's attorney, because they get done fast, there's only a handful of documents, they sign stuff and then they're sitting there. They will occasionally say, you want me to do that? And they will explain the documents to your client. It's a very friendly environment. Nothing like a residential real estate closing. Seller gets out of the place, gets cash, buyer gets the house of their dreams. Usually everybody's happy. Rare case somebody's crying, but that's very rare. So again, attorneys are helpful, but try and avoid that situation where you're acting or in a position where you're trying to act, almost having to act as your buyer's attorney. Other thing to be advised is that attorneys, by ethic, are supposed to communicate with other attorneys. So when you're involved in the deal, once the deal goes to contract and this is all paper, the attorneys take over. I think we talked about this a little bit already, so you got to stay involved and make sure that you stay involved in the business deal and don't get outside the loop. Make sure you know what's happening. But things like the inspection issues, you need to bring them to their attention and let them direct, because they're going to have to write the letter. You may have to help them write the letter, but they're going to write the letter to the other party's attorney. Now, if the buyer has no attorney, then as an agent, you're communicating that information. You're going to have to put it in writing. Don't send it to the other agent. Send it to the seller's attorney. All right? So that's how that communication is going to end up working. I mean, you can copy the agent, but you've got to involve their attorney in that at that point in time in that process. All right, so let's see what else do we have on tap for tonight that we can cover in 9.5 minutes. Yeah, we'll spend 10 minutes talking about listing presentations. I didn't have you read it, didn't have you print it out. I don't know how super critical it is, but again, I want to point out that there are documents that are up there online that you should take a look at if you have the opportunity in the class. But just as important as anything else, understand that what is available to you there is straight off of NAR's website, National Association of Realtors. I think I brought myself copies down. I probably didn't. So once you become licensed, you can get if you become a realtor member, which I'm assuming most of you will, you can get all kinds of hints and tips and tricks from NAR and IAR. Those are all there for you. Read them, cherry pick them, figure out the ones that work for you, study those kinds of things. Remember that when you when you go to a listing appointment, you're there to not only generate business for yourself and for your brokerage firm, but you set a tone. And the tone that you set will go transfer through all the way for the entire transaction. Sort of how you are going to stage the listing, what's going to stay with the property, how you explain agency representation to the seller, how much they trust you, how you do a market analysis and what's going to matter there, how the property is staged and presented and what data is put into the MLS. All that matters in terms of how buyers perceive it. So study that and learn that particularly well. And polish your presentation skills. Whether you're pitching to a buyer to represent them or pitching to a seller to represent them, you need to know agency well enough that you can explain it to them because you need to disclose it. You're their designated agent. But you also can use that as a tool to point out all the wonderful things you're going to do for them. Exclusively represent them, send them every possible listing in the market, or hunt for every possible buyer in the market, or whatever things you're going to do. Learn how to come up with that. So for whether it's listing presentations or whether it's talking to buyers, prospective buyers, you need to learn to sell. And you need to learn to sell you. And if you're uncomfortable selling you, then sell your broker, sell the firm, sell their experience, their name, their brand, the fact that you've got 50 agents in the office who are all going to be looking out, in theory, all going to be looking out for buyers or whatever you've got to try and sell. But learn that stuff as quick as you can early on. I know, for a lot of people, come to these courses. I like real estate. It's fun. I would like to show houses. My friend is a realtor. She's an idiot. She makes money. I got to be able to make twice as much money. Whatever it is. Very few people come to this class going, oh my God, I love to sell, and what I really want to sell is this. Selling is a fun thing. Selling is a good thing, and it's not hard if you really like what you do. And if you're excited about a property, if you love an area, for example, before I got into residential agency, I moved to Aurora, I mentioned 1980, and I grew up in Naperville. Homes were so cheap here, I couldn't believe how much less expensive a person could live in Aurora than Naperville. And there's all kinds of wonderful places to live in Aurora. And so it was easy for me to convince other young people my age to come to Aurora and buy a house. Why are you renting in Naperville? Why don't you come to Aurora and own? And many of those people ended up owning 3 or 4 houses before they ever left Aurora and moved wherever they ended up moving. And they too were pleased with the experience and what they had. So find something you're excited about, because selling is easy when all you're doing is sharing your passion or your excitement for something. If it's the school district, if it's the architecture, if you like I love the architecture, kind of sort of from west of the river on out, maybe not quite to Edgelon of that. And there's kind of blocks and pockets in there where it's just really cool, unique, one-off homes. It's much easier for me to sell in that area or take people through that area because it's fun, it's interesting, it's an adventure kind of thing. If you can do that, that's selling. It's not a hard thing to do. You don't necessarily need a Dale Carnegie course or take a specific class in personal selling, but it wouldn't hurt. Tom had asked about classes about some of that kind of thing. You don't have to take those here. You may be able to get that training from your broker. So that's another thing when you're interviewing brokers, if you don't know where you're going to go, ask them, how am I going to get this selling piece down? When it comes to listing presentations especially, I suggest you see if the office already has a folder, a binder, or if they already have a canned presentation you can put on your laptop or your tablet. So all you have to do is fill in your name, that house information, the seller, the CMA, whatever, and all the rest of the stuff is there. And you look at it as they look at it, and it's like PowerPoint slides. For those of you who are in the 100 class, all my notes are up there. You see them at the same time I do. That's the way a presentation would be, in a listing presentation. I used to do it out of a notebook, and I would do it upside down. They would see it all front, and all I needed to do was see pictures, upside down words, and it would trigger what to do next, and what to say, what to talk about. And I would customize those presentations for every listing. Until I'd been in the business for a couple of years, and I said, who needs this crap? And I haven't done a presentation since. But they're good tools, and some agents live and die by them. Know what you can and can't offer as early as you can, as also when you get in the business. If you're presenting competitively with listing appointments, sometimes somebody else will have come in from another office and they will have brought in fancier tools and other kinds of things that they're going to offer that seller. They may be trying to charge them a higher fee to get them, maybe not, but you need to have a sense of what you can do. So somebody says, are you going to advertise my house every week in the Chicago Tribune? No. Or, sure, If you don't know, you don't know how to answer that question. You don't know what the costs are. So understand how those kinds of things would work, or social media things that you can or can't do or whatever. Have a sense of what you can do. You need to be able to adjust and make some decisions on the fly. So for your first few listing appointments, ask somebody else to go along with you. If you have to pay another broker in the office a little bit of money, offer to take them out to lunch or whatever, find a buddy, find a mentor. Some offices have mentoring programs. So how it worked for me real quickly, and then we'll call it quits for the night. I was one of a handful of men in the office that was dominated by women. And I think I get along pretty well with anybody, but I felt uncomfortable as a married man going up to a woman anywhere around my age and saying, hey, can I hang around with you all day for the next 3 weeks while you go everywhere and do everything? Now that shouldn't even be funny, but it is. And so there were no men in the office for me to hang around with. Nobody for me to pattern my business. Within hardly any time of being in the office, I was the top producing male in that office. And when women would come into the office around the same time that I did, or shortly thereafter, they were able to find a buddy almost immediately, and they would have another gal to hang out with. So they were getting mentoring that I wasn't getting. Find that mentor, whomever it is, so they can go with you. As I was transitioning out of residential into commercial, and my wife stayed at the local Coldwell Banker office when I went to manage a commercial office elsewhere, odd as this may be, I got that brokerage, the local brokerage's permission. I was her mentor. Although she and I had done business together, I had always done the listing presentations. So for the first 3 listing presentations she did, I went along. And at the opening, we explained to them, my wife and I have been a team together for years. I've always done this. I'm now managing a commercial firm. I don't work for this firm, but I'm just here as her mentor. No sellers, I don't even think they knew what I was saying. But that way I disclosed I wasn't also part of her team. And after those 3 presentations, she was good to go on her own. And of course, she could still ask me questions, but and that was, like I said, it's an odd circumstance that the 2 of us would be employed in different places, but that's how it was. So find your mentor, find somebody you can rely on, and learn as much as you can early on. Again, once you've done 2 or 3 residential deals, you can do 1,000. It's an interesting business because every day is different, but in residential, the process is always the same. The steps are always the same. And so it doesn't take a lot of transactions to sort of know what you're doing. Questions about anything at all? Steve?
A 30-hour new broker REL,
The post-license course?
yes. Is that a set parameter of what's going to be in that class, or can you pick and choose some things you're interested in and to get your credit hours?
It's all set. It is determined by the state. All of the pre-license criteria comes to us on a spreadsheet from IDFPR. So I deviated a little bit in Real Estate 100 in that I don't specifically count the clock hours of careers in real estate, right? So I kind of tend to weave that in, but for other brokers who've not had much of this experience, they've had to go do things like study project management or property management and other things to be able to give people, here's what a day in the life of a property manager is like, here's what you might do as an appraiser or something else. So in that class, for us at Waubonsee, the first section of it, we're only going to do it online because it's all review, and it's just a matter of take a bunch of tests. Once you think you're ready for this, then just take the final. And it's not going to be complicated. It's only going to be a single 28 question final exam. And the other 15 hours, which is interactive for us here, will be face to face. And these are for us. We're going to offer them in the spring a year from now. We're not doing them in the fall. We're doing them in the spring. End of January, beginning of February, end of February, beginning of March for those 2 sections. So that's kind of how we're gonna be looking at it. Whether you decide to take it here or decide to take it anywhere else, I think you're going to find the same thing. It's kind of scripted. All these classes tend to be fairly scripted. 100 is so long, we've got a lot of flexibility. But from this point forward, everything you're going to take in real estate is pretty well scripted. CE is even more so. I see instructors working off of notes. They say the exact same thing, teaching right to the CE exam. Going forward, it's pretty much all just review, unless you consciously decide to take a course you've never taken before, like the ethics training that NAR requires every 4 years of its members, or, as I've mentioned to some of you before, a course on assistance animals, something that you've not seen before. Every 2 years, you're going to see the same CE. And the broker post license is just a mini version of Real Estate 100 and Real Estate 105. It's just review. There's nothing new in it at all. If you take it from me, I would be happy in the face-to-face 15 hours to try and, answer whatever questions people have. But the first priority will get everybody through the test. There's nothing else but the test for those courses, right? After that, it's like a CE class. You pass it or you don't. So the big thing is to just get everybody through it. Any other questions? Have a lovely weekend. Case studies 3, 5, and 6 out of your outstanding textbook for Tuesday night. We'll go over that and anything else that we have time for, but those will probably be sufficient. Please have those done for Tuesday.